Namaskar and welcome on the e-platform of GLS Law College. We are so happy today that on World Intellectual Property Day, that is World IP Day, on 26th April, GLS Law College has arranged a special webinar and a guest lecture on this day. So we are so happy and so glad that we are having with us uh, Dr. Vivekanandan sir, who is the Vice Chancellor of HNLU, and sir has kindly consented to deliver a guest lecture on e-platform of GLS Law College today. Sir, on behalf of GLS Law College, on behalf of Director of GLS Law College, Dr. Mayuri Pandya, uh, the team of GLS Law College is so happy and grateful to welcome you on the e-platform of GLS Law College. Welcome you, sir. We heartily welcome you here. And we are so happy that GLS Law College is always there for knowledge enhancement of its students and the viewers at once. And sir, you are the right person to shed light over any subject that is related to intellectual property act. Your knowledge, your dedication towards the subject is a great thing for us to know. And as you already know, Dr. Mayuri Pandya, who is an exceptional academician and who is also the quasi-judicial function she is executing, being an expert member of Environmental Appellate Authority, Government of Gujarat, and she is also the authority at national level. Once again, we welcome you on the e-platform of GLS Law College. So, welcome, sir.
Thank you.
As you are aware that today is World Intellectual Property Day, and it is said that it was the event. It was established by WIPO in 2000, and the object behind it was to raise awareness how patents, copyrights, trademarks, and designs impact on daily life, and especially to celebrate this creativity and contribution made by the creators and innovators to the development of society across the globe. 26th April was chosen for celebration of World Intellectual Property Day. And as I think, if I'm not wrong, it was entered into the force in the year 1970. And each year, the messages associated with the event. And World Intellectual Property Day 2021 shines a light on the critical role of small and medium-sized enterprises, that is SMEs, that is how we call it, in the economy, and how they can use intellectual property rights to build stronger, more creative, and resilient businesses. Now, it is a great thing, and on this field, it is a landmark day in the field of IP, and GLS Law College takes pride in for one thing, and that is for today, sir, on this day, in your presence, with your kind consent, we wish to inaugurate the IP clinic of GLS Law College first, before your expert guest lecture begins. So, as it is on virtual platforms, sir, virtually we will be inaugurating the IP clinic. We request you that you just virtually, we wish that you will be just clicking it. Here we go, and we are virtually opening the IP clinic of GLS Law College. It has the aim to aid innovative and advanced academic research in the field of IP laws for the legal and non-legal fraternity. Yes, we have opened the IP clinic of GLS Law. Thank you so much, sir, for gracing this occasion of opening of IP clinic at GLS Law College virtually. There are few information that we would like to share, that what functions IP clinic under the name of GLS Law College wishes to undertake. Here we go. We will take a look over there virtually. and once again, we all wish luck, good luck, and good guidance for the execution of this IP clinic under the name of GLS Law College. As Mayuri ma'am, Dr. Mayuri Pandya, the director of GLS Law College, has always been vigilant to start new things, new clinics under GLS Law College. We are already having legal aid clinic, we are having environmental law clinic, few clinics are into the pipeline to be inaugurated, and today on World IP Day we are inaugurating IP clinic. That is a great thing and a matter of proud and privilege for GLS Law College under the worthy guidance and mentorship of Dr. Mayuri Pandya, Dr. Vidisha and Ms. Forum Pandya would be the active members of this IP clinic. Those who are watching us, students, viewers, you will be having great benefits under this clinic. Now I request Ms. Forum Pandya, Assistant Professor at GLS Law College and young and innovative member of this IT clinic, to kindly introduce our guest of today's event. Over to you, Ms. Forum Pandya.
Thank you, ma'am. Good morning, respected Professor Dr. Vivekanandan, sir, and all the viewers. It is indeed my privilege to introduce the guest for today's event, Professor Dr. Vivekanandan, to you all. Sir serves as the Vice Chancellor of Hidayatullah National Law University, Raipur, and has been a legal educationist for over 3 decades. He has earlier served as the founder dean of the School of Law at Bennett University and served as the dean of the Rajiv Gandhi School of IP Law at IIT Kharagpur. Sir served as the MHRD IP Chair Professor at Nalsa University, Hyderabad, and was also a professor at the National Law School of India University, Bangalore in 2009. Sir was involved in policy negotiations at WIPO Geneva as Government of India representative between 2013 and 2015. Sir was also the founding director of the Legal Information Institute between 2010 and 2012. Sir was also an elected member of the Asia Pacific region at the at-large community of Internet Corporation of Assigned Names and Numbers between 2008 and 2010, and as the nominating committee member of the same. He is a member of the task force of the State Planning Commission of the state of Chhattisgarh. Sir teaches IP laws, internet laws, and corporate laws, and has been an adjunct visiting professor with the Business School of the Buffalo University since 2007 for their executive MBA programs on business laws. Sir had been a research scholar at the Maastricht University, Netherlands, and Institute of Intellectual Property at Tokyo in the past. Sir also received the Legal Education Innovation Award from the Society of Indian Law Firms and Menon Institute of Legal Advocacy Training in the year 2017. Sir also served as the jury of the CII, that is the Confederation of Indian Industry Innovation Awards Committee between 2015 and 2019. Sir, we heartily welcome you. Thank you so much.
Thank you so much, Ms. Forum Pandya. Sir, now all the viewers or students and many experts even, they wish to hear it from you. That is policy and practice of IPR, convergence and divergence. Your expert views and yes, few questions if the viewers are having at your convenience, it would be asked. Over to you, sir. Over to Dr. Vivekanandan, Vice Chancellor of HNIU. Yes, sir.
Thank you. Professor Mayuri Pandya, Professor Payal, Professor Vidisha, and Ms. Foram Pandya. A warm good morning to all of you as well as the other students and viewers who's attending this IP Clinic inaugural program as well as a short lecture on commemorating the World IP Day. Let me tell you, it's a pleasure for me to be associated again within a short time with GLS Law College. And I fondly remember the last event which was attended by the GLS fraternity and others in an enthusiastic manner. And when Professor Mayuri called me and asked me, I readily accepted today to come over. So, and I would say that today, when we are in the World IP Day, there may be two things which will be crossing our mind. One is, are we in a very good mood and happy mood to celebrate it, or we are really looking around things which is very dark clouds with the second wave of COVID? And in fact, let me tell you, philosophically in life, always this celebrations as well as dark clouds alternate for us, even as an individual. Now, more as a country, and much more, it is not a question of withstanding some problem and coming out. Quite often, this has taken a very dangerous turn. So, what is one thing which we should remember today in this day to connect is that human evolution has always, fought back. It has tried to do innovation, it has fought back, and that is a very, very crucial part. And probably one of the things what we can do today in World Intellectual Property Day is to have the foundation thinking that uh, the, the, the knowledge around us and the observation what we do, and then how do we connect and try to, what you call as protect human beings as a race is an integral part, especially in innovation relating to medicines, vaccines, and other places. There are two types of innovation. One is fundamentally what you call as for our comfort zone, making it faster and making life much better, which you consider a lot of machine related, technology related, things. For example, all of us are connected today is thanks to, evolution in technology innovation. But the other side is also survival, which we find quite often that in spite of all the great knowledge understanding, survival itself is at stake. And this is where the whole area of medicine, many things are coming in, and medical equipments, medicine, and various innovations are happening. Then this obviously takes to us a question: is innovation is something which is a matter of everyday routine, or is it so naturally happening, or it needs to be, cultivated? The answer could be both ways. At times, we innovate great things just in a flash of a mind, and but at the same time, a lot of other innovations doesn't come by a flash. It does come by a methodical planning, a methodical way of investing, methodical way of executing it also happens. So that we can understand that a large scale innovations, especially in today's world on these areas, requires a lot of people to come together and do things. For example, let us say this pandemic, how we are fighting. On the one level, inside certain parts of the world, in certain laboratories, scientists are day in and day out trying to analyze the structure of this coronavirus, taking the virus sample and then trying to see how it is and how does it affect and what could be the antibodies which should produce to fight it. So this is a relentless thing which is going on. That is not simply one part of pandemic fighting. The other fighting is on the internet side. We are doing tracking, we are doing many things. I recently came across a couple of days back, somebody forwarded to me of IIT Delhi, which has done a app which even tells to a great level where hospital beds are available. Because one of the things is that we know that we may not even know that nearby there is a hospital, there is a bed. This is where internet coming and filling up in many, many ways about a fight, because that's also crucial. Apart from vaccination, trying to reach a particular place and try to get medical attention. So you really find databases, applications, many things what is happening. Not necessarily very modern medicine. A lot of people often we see in WhatsApp steam inhaling in the initial stages tries to control immaterial of what is its effectiveness. That scientific database, it's a much simpler thing which is being spread. So in fact, in a way, our social media, WhatsApp, many things have come to the rescue. So you find in every aspect of moving to a comfort zone or fighting deadly things, innovation needs to be brought in by a collaborative effort, a lot of people to come in. And this probably also takes us to the very important question: are innovations just come without any cost and investment? The answer is no. All of us know that all of this requires a certain level of investment, a certain level of business structure, etc. This is what I call the early type of science. What human beings occasionally were doing is lab to the market. But today we have another interface called law, and that's where intellectual property rights and your own clinic today and its purpose, which I will explain. So the whole question today is trying to put it in a structured way, trying to incentivize a group of people who want to put investments there and try to go towards certain focus. No doubt, all these investments and innovation is towards a common purpose. But at the same time, the question comes, who will invest? That becomes a very crucial question, which many times we could be very idealistic and romantic and not looking at that point. If I'm going to ask you and me that, why don't you put some money in this? Normally, let me also even tell you, a human psyche, we look at what others do. And if others are benefiting out of some investment, we too try to go there. So there is a tendency to see that safeguard myself. Why should I put in some hard-earned money? And if there is, if it fizzles out or dissipates, what do we do? So this is a very vexatious question. That on one side you have to balance return on investment. On another side is a crucial part. Why do we do this? Is for everyone to get access, at least for fundamental or important things like health, if not for very luxurious machines and luxurious gadgets that could be even foregone. But fundamentally, health becomes very crucial. And nobody has a magic wand or a formula to perfectly do this. All of you must have been watching last few days about the debate everywhere about the price of the vaccine, what it is going to be, whether it is going to be given. Of course, government is has given it free in the first few stages. Will government have a deep pocket to keep it free and give everywhere, or can companies give it free to you? All these are all questions not very emotively answered, but need certain level of pragmatic economic sense. I am no way telling that what is the price prescribed is the right one or not. But what I am trying to tell, that all of us know that everything is a resource and everything has a value proposition, including a student paying a fee, including a teacher demanding a proper wage, including someone trying to organize these things. So it is in this context very, very important. World Intellectual Property Day, we should remember in the first place that it has brought back the focus of public health in a big way. And whether World Intellectual Property Rights Day commemorating today, we should look at a new way about trying to distinguish between intellectual property of a comfort zone and intellectual property of a fundamental need. That's a very, very crucial part. Or in other words, whether do we have a kind of theory and policy in the same way to do. That is my starting point. The second point, I said that I will even come to what are the convergence and divergence. Probably the best at this point of giving few minutes of introduction is to go in a next 10, 15 minutes, 10 minutes or so in a structured way. Let me share. I hope I have my screen sharing facility, right? Right. I'm sharing the screen with you all. Just a second. Is my screen visible?
Yes, sir, it is visible. I'm just taking it. Yes, sir.
Excellent. Now let me put my PPT here. Is my PPT visible now?
Yes, sir, it is completely
Excellent.
visible.
Excellent. So I'll quickly take through because it will be less tiring when you look at slides, easy to follow. So when I said IP before 1995, I'm talking the theory practice conundrum, or rather, how is what you call as theory and practice. Theory was it is distinct, varied among nation states. Each country framed its own. Some don't want, they don't want because it's sovereign. diverse based on historical narratives. If you are a colonial country, you had a different narrative. If you are a country occupied by someone, you had a different narrative about how do you even look at property, how do you look at distribution, how do you look at innovation. So it was rather democratic in a way. Choice was on a rainbow shades of extreme socialism, like even Soviet Union, which had a inventor certificate. They used to tell because private property was abolished in Soviet Union. Or other end of the spectrum was United States with capitalism as its cornerstone. So post trips, which I call 1995, makes a big change. TRIPS compliant, if you are a member of WTO, you have to be. Exemption to be based on what was agreed upon TRIPS provisions. International IP regime complex as the agenda setter and arbitrator. So, in a way, it is not everything starting domestic and ending domestic. We are really looking a great level of international, agenda coming in. The first world and the third world as a referral point. All of us know we are in the third world in a sense. We are sometimes thinking that we are moving towards first world, but very technically with GDP, many things, many issues, we will be definitely third world in terms of classification. The second world, as you all know, Eastern Europe and Soviet Union, in that concept itself is vanished in a sense. Either they are trying to move towards first world or some can be categorized part of the third world. Now, third world and IP, I call it Read India. In 1995, suddenly IP became the big topic, especially law schools. And in science technology, it was not even heard about. What was it? Simple. We went and signed the agreement, and then we wanted to get ready. It, in a way, is putting what I call the cart before the horse. You want to drive, but what is the horse? When I mean the horse, the entire people who are going to pull this new regime, which we have signed in trips. I wouldn't say we were zero, but we were not the horse which were trained. Now we are talking about a great march forward. What we are talking is, right, we want to now show incentive, do this, do that, etc., and reach the target, the carrot, what we call as the IP, incentive, targets, etc. Now, this is a big question all of us have to think today in a way and then try to see whether what is the kind of convergence and divergence. If I use a cinematic expression, I call that as a matrix. What is the matrix? In pre-trips, Indian matrix. As I said, we were totally what we are calling today be, vocal about local or make in India. It was even said at that point of time in 1959. It's not, in a way, totally new slogan. In fact, the original committee which changed our IP law said we need to be looking inward to do things. And nobody will tell this was the wrong policy because let me tell you, you're all from Gujarat, the entire another big capital. I am from Hyderabad, and these two are would easily share the honors for the pharmaceutical industry. And let me tell you, that is thanks to certain innovative tweaking of our policy, we could really, really, really catapult ourselves for our indigenous strength and try to do because if you had gone for a global policy at that time, I have my own doubt whether India could have been a pharmacy to the world as it is touted today. But as I said, you cannot be sitting in 1959 and 60, but even in 1980, when Indira Gandhi, our Prime Minister, spoke in World Health Assembly, she even was very skeptical. She said a better ordered world is one which is free of patents because she said we should not profit from life and death. Some of you may think that is even echoing in pandemic times, this kind of argument. We need to take all kinds of things because we are not talking about one story of IP. We are talking about multiple stories of IP. So what is it? India in post trips, again, another prime minister I'm quoting, who was at that time, 2005 was our laws change. India will comply with all provisions and obligations of international treaties. You may wonder, was it a sudden, huge policy revelation or a kind of wisdom? The answer is not wisdom. The answer, I call it as TINA. The word TINA is used in management theories, TINA. TINA means there is no alternative. So that's a kind of situation because we are talking about WTO benefiting you in many other aspects, but we were certainly not in the forefront of innovation. We were certainly in the forefront of technical competence. There's a difference, innovation and technical competence. Technical competency is simple. If somebody tells you how to make a dish in the kitchen and you follow, or you follow any of the YouTube thing and you do that, that is called technical competence. If somebody is trying a dish first time, which happens to be really good, that is called innovation. So the whole difference between third world and first world, in a way, which we have to acknowledge, is, in many aspects, is innovation happening in another sphere, whereas technical competency happening in the second sphere. Technical competency is always dependent on license from the first world. So this is where the whole, I call it, economic power base, first world, third world, developed, underdeveloped, all this matrix is happening here. So it is probably, we thought we will catapult ourselves, some kind of hope, etc. If I put the matrix reloaded, I call it, in a filmy way, if I had to put it, what happened post that 2005? We started putting capacity building. What is the capacity building? Who are the players? Naturally, in a third world, government is the biggest player. Political parties, because they influence government. The capacity of government, when we say it, is nothing but the heart is political parties, the brain is the government. Then we have business. Who are the people who invest, who can think in a macro level, who can take risk factors? Then we have academics like you, me, everybody, who play a very big role in sensitizing the good, bad, ugly of anything. That is our role. We are not government, we are not political party, we are not business in the strict sense. We are, in a sense, a conscience keeper. Then you have media, the greatest disseminator. And then you have civil society groups, which also place tremendous amount of passion, tremendous amount of fight back on many things, as civil society groups is a major offshoot from media as watchdogs. These are the capacity building. In academics, let me tell the frank part. During trips and even post trips, I was involved in some negotiations. Minimal participation. When I say minimal compared to the first world, where top level academics play a very major role. For some reason or other, academics either are diffident, or importantly, I will tell, they are never recognized as a major one. Not this government, I'm telling, any government I've seen, that academics are what you call as, hey, you go teach. That we know how to take care of practical things. But let me tell you, in the West, its academics play a very, very smart role. So it comes two ways. One, you need an opportunity, and we should be equipped also. That's very important. It is not coming and talking about a textbook somewhere and then going away. That is not academic, what I mean. Reliance on theories and inputs. What do we do most of the time? If you look at a syllabus or look at our books, etc., it's very easy for us what a John said, or a Smith said, or a Jane said, or a Mary said. Lack of a tradition of public policy debates has been there always with us. We really don't get into public policy debates. We want to say that is left for political parties. That is not the point. Political parties are what you call as the game of power and to do things, but inputs have to come in a level from academics. This I want to point out. So you can see the theory part, when I say, itself is not strong in our sense, or our theories is not the same theory which we thought useful to us. It is a theory from outside. So now, is it the same? Is it changing? That's my opinion. I'm combining both convergence and divergence through these slides. Matrix revolution, if I put it, the impact of teaching and public policy, we started realizing there is something in the room. What is in the room? That we are still trying to grope and trying to find out. What is the public policy we are trying to teach? So the teaching status, all of you know, it's not a compulsory subject in many law colleges. I'm not talking GLS or HNLU. We are much, much smaller creep. National law universities, definitely for the last 2 decades, they're having compulsory. Simple, one semester you put like a smoothie or in a mixie and then give everything. A handful of universities offer specialization at master level. I'm not blaming, with so many subjects with BCI prescribes what a lawyer has to equip. It's competing for space. So IP becomes a problem Then one semester you teach copyright, trademark. It's like sampling, and then try to say that, oh, this person has completed IP, because the subject is very very vast, diverse, has a huge other components. So copyright, trademark, I would say adequate case laws in this country, because we have been practicing that quite some time. Patents inadequate base, reliance on foreign case laws and jurisprudence, which many times doesn't make sense to many of us, except for memory and other things. That's all. You can only impress a foreign professor with your knowledge about what happened in America, but here it is still a non-starter. Trade secret GI or new to academics, of course, people are doing. I'm quite happy they are doing that. So understanding copyright in digital environment is, in my opinion, a very slow starter. Why I'm putting all this: when you're starting a clinic, when you're trying to revamp your curriculum, all that, let us move forward. There's no point in looking at backward and trying to repeat things. Setting the syllabus is easy. Finding teachers is the challenge. That's a big problem, because whenever some new subjects is exploding, especially when it has commercial value, definitely market pays you many times than being an academic. And academic, you cannot, because academic definitely has to be certain level only you can pay, because it is more a service rather than a kind of a competing process. So a colleague of mine long back used to tell, he wanted IP course. I remember him in Pondicherry Law College, when late Professor Menon was the principal. He said, "Sir, he said, 10 of us want to do IP. Can you teach us?" Then he said, "No problem. Bring a teacher. I will allow you." But things are changing now. I'm quite happy to participate today, or a couple of more programs today, that IP teaching has come of age, at least in terms of teachers availability and people who are passionately taking. But at the same time, no compulsory component of IP in science courses, because you need to know IP is not a single one, it is a joint venture. Trend of publish and perish is changing. So, in fact, IP is a joint venture between science, technology, management, and law. Looking only at law, we are not going to move forward. Similarly, somebody who from science and technology, what is patent filing or what is innovation, that's enough, not enough. They need to know that this side. So, what is an invention in science is not an invention under law. Hence, the basic understanding of IP law is important. More seminars I find in the past 10 years than past 10 decades. But the trap many times I find is, I consider trap. I am also falling in the trap at times. Repetitiveness. Are we setting a seminar which is something, sparking a new thing, new thought process, however contrary it may be to established practice? That is very crucial for academic. Academics is not about, taking from a masala box and putting every day and making something. It is about trying something new. A focused training is important. Need for proper training manuals is still a far cry. Need for segmenting target groups is still a far cry, because IP is not same. One size does not fit all, they say. So, what is required in training? You need a national IP academy. I know there is some academies are coming. In Nagpur, there is one government-sponsored academy. But still, I would consider. I always consider anything which is an appendage of government. Quite often, the problem is it will start inwardly looking. You need a vibrant national IP academy which can criticize universities, which can critique government, which can critique many things. Critique itself is nothing wrong. Take the critique, and from there you take a oversight and do that. That's a very, very crucial part, if you have to understand why developed countries are developed countries in a sense. I am not exonerating developed countries as paragons of virtue. But what I am trying to tell, you will find at least these type of independent think tanks are important. Need nodal centers. You need to draw a matrix of sector skills, manuals, and certification, because IP is not just about litigation. We're talking about initial thing. That is about the whole gamut of policy, and this is where I say a theory and practice. Otherwise, people ask me, should theory fit the practice or practice should fit the theory? My definitive answer is practice has to fit the theory, but the theory itself cannot be something else, right? which also needs sometimes. So, is your feet to fit the shoe or shoe to fit the, you know, thing? You need to have, make the shoe to suit the feet, but at the same time, you may have to do few things of adjusting how the shoe should be worn. So, this is a kind of a gap which I consider is not something definitive, a formula, but needs to be focused by every institute how to do that, and sometimes very collectively of IP teaching. So need to train vast number of legal practitioners who have missed the bus. Remember, not the young one who know IP. There's quite a lot of people, right? Bar Council has to undertake the task, but I know with current structure, what is happening, they are probably at their seams, even not able to inspect schools. But then probably good universities, regional networks, for example, Gujarat. If I take your GNLU, your GLS Law College, you have some independent, IP academic think tanks. All of them can come together. Need for sensitization, a need for civil servants and registered or basic training, because they are going to play some crucial role. So IP research, in my opinion, a non-starter. Need to identify needs of the country. IP history world over, let me tell you, is tailoring to the country needs. Country is there, TRIPS is also there, right? Because of TRIPS, not our borders, our sovereignty is gone. So this is very, very crucial. Need for a forum to have a dialogue between legal researchers, scientists, and industry managers. Quite often I find CII or FICCI will do, only industry people will be there. I will see some academic conference, no industry person will be there. And scientists have no clue. Sometimes they take some little lecture and go away. So you need an interface of law, economics, management, all that together, which is next many times this is too ideal matrix. But there is no other choice to move toward that direction, because keeping in silos is not going to happen. A national grid of IP chairs, centers to exchange research ideas. So this is how to have the. So if I try to close my arguments, what it holds for future, to get the required blend of science, tech, law, and interface. The immediate goal is to cater to the practice. The long term is to breed researchers who are equipped with complexities of tech law matrix. So we can't tell we will do some research what will happen after 5 years. You need to do day-to-day stuff, and then you need to do about long term. To design PhD programs which allows science tech aspirants to do IP research without formal law background. In fact, HNLU PhD allows, even if you don't have a LLB or LLM, but if you are nuanced with law, whichever science technology, you can prove yourself, take some foundation course, and you can do a PhD. I'm pretty sure UGC allows this. Many science technology allows, and your institute also should think not just simply keeping law alone in a sense for IP. So if I take the last part of my series of movie, I call it Path of Neo. Traditional IP theories need to be audited. Locke, Hegel, Statute of Anne were pre-industrial fundamentals, suited a particular geopolitical economic property model. Asian property jurisprudence differs significantly. It requires a variant, as one size does not fit all. Always, Asia has been a client continent. It's time with, I call it India and China, around 37, 38% of world population. 1 in 7% in the world is a Chinese, 1 in 7 is an Indian. And there are other Asians. If we really, really look, I don't know why we cannot look for our own, method of doing things. So, where without a global passport and visa, a global IP model, in my opinion, is anachronistic. Who is at the center? We have to often redefine. Is it the consumer or inventor? My affirmative belief is consumer. Inventor is working for the consumer, not the other way around. And this is often lost in terms of IP discourse of theory and in practice. Basic versus luxury, which I told you, in shaping the delivery agenda. Public goods versus private luxury. Development versus wealth creation. Can you say only development, no wealth creation? That is again, each one of us know. Each one of us want to get our basics. Each one of us also want to improve further. This is same in society and countries. So you need a kind of a judicious mix of what we are talking development on wealth creation, which which is nothing but a future risk management, having wealth. Effective IP clinics for students. I'm quite happy to be part of your is very. It looks like a very small event today, but I'm sure that in the decade you will see, you will remember this day how the seed was sown and how the IP clinics. So foundation course on science and technology for patent and copyright specialization is very important as part of the clinical courses. Patent search and drafting exposure to law students, even though they are science technology domain. As much others need to know law, how to talk to a lawyer. A law student needs to know how to talk to an inventor. So definitely patent search modules, drafting exposure is important. We have done that in NALSAR. We are doing it in HLLU. I'm pretty sure that any help is needed, institutionally we can help. Internships with patent office is also quite crucial to get a complete ground level reality of that. So the concluding remark I would put it, current capacity building in an Indian context is based on the force called IP as lex specialis or legal speciality. It is in a search of a policy and practice suiting the development agenda. It will have conflicts with lex specialis jurisprudence of science dominated models. So we should not be worried about conflicts. In fact, if you are talking improvement, progress, we need to look at conflicts. As long as conflicts are solved in a healthy way, in an incisive way, in a way you try to see things. That's very, very crucial. Quite often we think it is no conflict will move. Conflict, when I meant not destructive, conflict which is constructive. Searching for alternate models of blending science, and I call social obligations. Because remember, it is not science alone which leads the world. Or why science? What for science? It is for us. And so this blend is very, very important. So IP is not golf, but a football game. It's a techno-legal process impacting all, and hence incentive access balance is very, very crucial. IP clinics bridge, in my opinion, the theory and practice and can manage convergence and divergence dichotomy. Don't think theory should be there or practice will not be, or vice versa. Same way, convergence and divergence, let me tell you, is part of each of our DNA. We converge and we diverge every day, not just with others. If you start deeply thinking about yourself, you at times you will be comfortable with you, at sometimes you will not be comfortable with you because there is a divergence happening. It's a continuous, I would call it a mysterious creative force which keep happening around us by nature, by these type of pandemics, by even countries, by society, by politics, by business. You call it family, friendship. I said even individual psyche. We have our own convergence and divergence dichotomy. So I would like to say how we have to be creative in managing theory and practice and convergence and divergence. This is what I want to close with a thank you for all of you to listen here now. Right? Thank you very much. Over to you.
Yes, sir. Thank you so much for shedding light over the topic, sir. We are so thankful to you for the same. We are having few questions for you, sir. With your kind consent, we would like to ask you as per the time limit. Shall we go with few questions, sir?
I'll try my best to answer.
Okay, sir. This is a question that one of our senior faculty members wish to ask, sir. That now we have modern economy called GIG, that is gig economy. Does it affect or influence trademarks or trade secrets in any way? Or we need some understanding on this point about
Can you,
gig economy, sir.
can you come back to the first line, what you said?
I just said that as now we have modern economy, that is gig economy. So does it affect or influence trademarks or trade secrets in any way?
Certainly, let me tell you, certainly somebody said the internet is the biggest copying machine ever invented in the world. And I mean, if you look at internet as process or if you look at it as a machine, it is the biggest copying machine ever invented, they said. Now look at thousands of places. Earlier in a street, somebody starts with a trademark, you file the case, stop them. Today, you don't know, millions and millions of trademarks are being used without anybody's permission. Similarly, even trade secret, what you call, let me tell you, what you consider as a trade secret is next minute in WhatsApp, right? The whole world knows it in no time. So, in a way, that is where I said your whole theory of trademark and trade secrets needs to be realigned. Is there a proposition why we should protect trademark? Yes. As I said, consumer goodwill, many things. Do you have a proposition in terms of what I call as trade secret? Yes, but at the same time, what do you do? For example, one person, a very top, I don't want to reveal the name, a top newspaper baron asked me this question in a personal discussion. He said, our newspaper, many things what we do is taken and put in different blocks. So you tell me what is the kind of legal action I should take? Is it correct? I said, no, in our current law, that if you have done now a particular story or something, not a general news, if you have done something with collected, put in efforts time, the copyright belongs to you. And somebody else should not have taken and put it. So, what is the way out? I asked him, how many people you are going to file case and arrest us? Second question I asked, does it damage monetarily to you? He said, not really. Don't you think that if you are able to persuade them to put the source and allow it freely, won't you get your brand equity much bigger than what you are reaching through your print media or whatever internet media? Right? So, this is the trend. If you see many music companies releasing their songs free in YouTube, you get my point. So, it is innovation in business model is happening. No? Innovation in business model. We think innovation only in theory. In practice, innovation is happening in business model. So what I am trying to tell, they say if you can't beat them, join them. So in one sense, that's also a way of we need to look, because if I'm ritualistic telling what is the act said, what is section said, I will only be teaching. You get my point. But if I'm really looking, that's where I said it's a innovation in law, innovation in technology, innovation in business. All three combines. In that you get a new model which is happening. Right? The whole Creative Commons, brought by Professor Lawrence Lessig, allowed certain level of revenue as well. Oh, why Apple? When they went with Apple iTunes, $1 per song, instead of paying $39 for an album, which nobody wants for one song, and then they pirated. They said take $1 and take license. They got huge money by because generally people want to be lawful. Let me tell you. Why you are unlawful? Let me tell you. When you become too pragmatic, you are unlawful actually. Because you find supply, demand, many things, then you think, law, let's take care later. Let me survive first or get something, then I'll become legal. This is a trend, I will tell you, right? This is a trend everybody has. You get my point? As a student, I must have had the same thing. You get my point? So the point, what I'm trying to tell, why don't you make it creative in a way that I get maximum compliance? I don't know the specific incident what they are talking. So my general answer, trademark, trade secrets are concepts. But beyond a point, enforcement is going to be very, very difficult. So you work out a method that a person uses your trademark or certain level of trade secrets in a way that you don't lose something great and you don't waste money. Because let me tell you, in IP, litigation is not the first choice. It's time bound. After that, there's no use also beyond a point. So you need to work out formulas to, get the business going, right? It is not, let me see, and I'll fight till your grandson's time and then win the case. That is okay, normal property where your price will increase, but not with intellectual property. So this is very, very important. I tell my IP law students, don't start like a hungry litigator. Litigation you have to do, but look at yourself as a IP manager. How do I make deals? How do I do? There is a win-win situation. That's very, very crucial because this is time bound. It has to come within a period, generally speaking.
Thank you so much, sir, for explaining it in a very simple and in such a clear way. Even we understood it completely when you gave the example and explained it in a very lucid manner. So thank you so much for that.
Thank you.
I believe that for the trade secret and all the things, many times in our country, the concept that goes on, that is buy, borrow, or steal, that is what it goes many a times. One more question that has for you is that what is the relationship between national IP policies, national IP strategies, and institutional IP policies?
Okay. My point is, national IP policy represents one way the entire government, all the stakeholders, and it has an interface with international. No national IP policy, as I told you post trips, can have its own narrative. Right? It has to, by and large, maneuver within currently trips and its flexibilities. Tomorrow we don't know what agreement. There are many agreements. That is national policy which is done. And national policy, by and large, keeps in mind about various different stakeholders and their power, like big industry, SMEs, and individuals how to do and how to stimulate. It's a huge package. Institutional IP policy, in a way, is what I can bite and what I can chew. That's very, very important, right? Because I don't prescribe same what is your capacity in terms of databases, what is the capacity of teachers, what is the capacity we'll introduce. That is very important. From here, I'm moving my standards to that. That should be the institutional policy. No point, but we all know that we love to have brochures which will tell the world is at our feet. That is more advertorial, I call it. But the practical reality is planning stage by stage what to do, how to move up, how to do things, and then how I produce something. This takes a long time. This takes a long time to do because national is something which has all its resources, all the power of the government to put and quickly move forward. Whereas institutionals always, I tell you, has to depend on certain internal resources, certain things what they do, availability of teachers, and many times some institutes add a little glorious thing, and then some few faculty move out, it dips badly because it's more about individual passion, strength. What happens? National is not individual strength; it is systemic way of doing few things and then putting it across. So that is very, very important. An institution varies from a law institute to IIT to IIM, where they will focus. What they have to do, they cannot be talking in an IIM. They will not be talking totally on law. They have to look at the business side of IP, licensing, franchising, what to do. Then science, they will look at more about filing, all that stuff. And law, predominantly, we'll be looking at sections and clauses and case laws. But at the same time, I said there needs to be some level of, I call it as borrowing, or a reverse osmosis should happen. Otherwise, IP is a very difficult thing.
Okay, thank you, sir. One more question that is from our student, that is Ranak Majmudar. She wants to know that what are the few changes which the IP field will see in the coming years? Say, for example, post pandemic.
Well, I would, at least this is my personal opinion, which is getting reflected everywhere. As I told you, IP cannot be again viewed totally as just exciting innovation. It has to look at, especially what pandemic has already taught us and already threatening us in a way because we are not yet come out of the thing. We are still, I don't know. We only pray that the worst is, not, to continue and it will come down to an end. Is simply about IP dealing with public health. right, is something which is, in fact, without that, your whole goal of luxury and other things is going to fall flat, right? Where will, when skilled, human resources gone, what is the big comfort zone you're going to do, or supersonic flights, or what we call as a latest, artificial intelligence based television? Am I right? So it's very, very important that you have a healthy society in order to do greater innovations. So for the healthy society, the IP impact, I'm not telling drug price alone, equipments, many things. I'm not telling, people sometimes tend to tell, oh, this poor state is because of unknown. See, doctors or infrastructure, buildings, and our effective way of managing, these are nothing to do with IP in one sense. IP has to do with drugs, vaccines, pricing, you get my point of them, and accessibility, and whether everybody rich also should be given free or poor should be given. That's a public policy, right? That people can judiciously handle, because government is government is not a kamadenu always to get money. Where they get the money from? Again, taxing you and me in one sense. So obviously, this should be the important, huge alarm bell, not just for India. This is happening in the West. They are also now have to go to the drawing board and talk about IP and development, which India spearheaded 10 years back. I was part of some of the projects. One of my chapter came in a WIPO book called YP Development Agenda, which I wrote, called Public-Private Dichotomy. Right? In this, now it was forgotten because we had a free run of GDP everywhere. Suddenly we were into a brave new world. And suddenly where we are now. And that again brings back to the drawing board. If you talk IP, how does it lead to development? When I mean development, it is not per capita income. It is about distribution of that income, distribution of our, wealth and health.
So, in continuation to the same, another question is from our student Rishika Srivastav. She wants to ask that in today's time of pandemic, again it is in the continuation of that. Is there any need to invoke the compulsion for licensing for pharmaceuticals in India?
My point is, see, this has been there everywhere. Two things are important now. One is a vaccination, another one is treatment, like Remedeshwar, you know, or a new one is going to come from, they say that Zydus, all that. Now, the question of compulsory license happens in when you don't get the drug supply, whether others have to do, so that it's faster. Second, if unaffordable pricing, etc. I would say that at this point, it's not a mechanical compulsory license. Take vaccine. Even if I give compulsory license, how many plants are having the vaccination production capacity? And vaccination can be very dangerous if things go wrong. So a huge FDA approval is needed, and human resources are needed. Vaccination has only been a smaller segment in this country compared to pharma products, because vaccination only comes when there is an epidemic or pandemic, which is not much. See, for so much before COVID, we never bothered. Very small. Chikungunya came. Even same Bharat Biotech went and patented it. But where is chikungunya? Because it just subsided. Zika came and then it subsided in many. So nobody is investing when there is something not happening. So it is very easy to tell at this stage that compulsory license. I still consider that government can negotiate on prices. They have the wherewithal to bring. Somebody asked me why Bharat Biotech and they are quoting high price. I said, India is a bit of a vegetable market. You ask more, they'll come down low. We have never been pragmatic in our pricing. Probably ask 600, finally they'll give you 200. Is Punawala and Krishna Ella exempt from this? No. Right? They would have also thought, we ask this much, they will come this much. And what is the rationale? They may have their own rationale how to do what to do. So it is not the question that we cannot have a home-based vaccination companies running. Vaccination, biotech is a long investment, remember, than pharma. Pharma is little easier. Coming to Remedeshwar, already they are doing. The problem is production capacity. Probably they can think or they can talk to the players. The players will be very much happy now to do on a proper compulsory licensing with a proper, licensing thing. Should we remove IPR at all? You cannot have a knee-jerk reaction on this because there's a pandemic. I remove IPR, then if I say I close my company and go, can I compel a company to run? Or with the same efficiency? It's not easy. That's what I'm trying to tell. Can government take? That's another question they're asking. In Tamil Nadu, there is a plant which was done 10 years back. 10 years back, they brought a plan to do vaccines, but they never did. In fact, last 1 year, they're doing sanitizers there. But I was asking somebody, why not Biotech take that? They said, see, they went and saw. They said they had some 200, 300 people. They are telling on condition you have to take all the 300 people into employment. But all the 300 have no connection with vaccination, frontline experience. So the company is hesitant. See, if you give me the plant, I can run, but I see there are a lot of complications. And Indian government has run many, many factories in the past, IDPL, many things. They did some smaller level vitamins, okay, but higher level, government has its own set of problems when it comes to innovation, dynamism, making fast decisions. That is one reason. So what I am telling, definitely compulsory license is a tool. If there is objective condition, I'm pretty sure that not you and me, government is the one which is struggling in a lot, they will definitely put it across. And that to a government which is in majority, we need not depend upon anybody's approval here and there, will certainly move into the direction. But as I said, there may be some backroom negotiations about trying to get the thing. It is not being romantic about compulsory license. It's about getting the medicine at a price which is up. For example, if you ask me, can you give 600 rupees to a vaccine? Happily, I'll give. Do you get my point? It just costs me less than a dinner, right, in a restaurant. So I will not say that, government should give me free. In fact, I went and took in a private hospital, right? I paid the money, whatever they asked, because I consider 600 or 1,000. But the point is, the vast majority cannot. So how do government do this, balancing act of people who have money can pay, people who cannot, at the same time, keep these companies going? Because the same companies is celebrated a few months back for, relentlessly pursuing and coming within a year. Pune wale, kept so much of stock. When they asked him, suppose you don't get approval, he said, it will be wasted. But when it gets approved, I can move fast, he said. Who will come for his rescue if you are not approved the vaccine? All would have gone the drain. So we need to really look, that's why I said, it's a more complex about how we are handling the whole situation.
So, one more question: that what are your views on India's initiative in WTO to write off IP rights on COVID-19 products?
See, India, in fact, has strongly and forcefully argued, if you read the statement of India, they have this new, what is called as the network of COVAX, where everybody have to supply for poorer countries. So that's what I said. It's a divided world where there are, people who afford certain sections, GDP, all that, certain things are not there. So the question of India did say about IP rights, but India will be now itself faced with its own two indigenous product inside, right? Whether it has to give IP rights. So what I am trying to tell, in principle, they said that this I consider always as, in a way, international level posturing, so that you are at least not insisting too many rights. On the other side, they will also talk about higher price, then they come to a balancing view about what to do. So that's what I said. When you say, what is IP rights in internationally? Internationally, it is too not pragmatic to think all countries are going to come to this. Especially Western countries, which have seen a great amount of success with their IP policies and wealth, are not going to easily now say that, oh, you have an issue, so we will write it off. They may give compulsory license in your country. That anyway is available to you under TRIPS within your country. To tell all of them to do, in my opinion, this is basically a rider on the conscience of the world, how they are really looking. For example, America today has come back and said we'll allow raw material. Last week they were telling they are not letting raw material. This week they are getting raw material because there is a very public consciousness occurring everywhere. Same people, each one of us in our family, one person is in America. And everybody tells, what is your country doing like this? So there's internal pressure. Yesterday, 2-3 senators of Indian origin spoke to Biden. They said, see, look, they are not asking you free, allow raw material. Don't be too much that we are going to reserve this for Americans beyond a point, right? And so I said, it's that kind of pressure what India is putting already in WIPO, in my opinion, is so that it softens a very right-wing stand of IP, I call it, right? To bring it to centrist view could be one of the things what they do. How it goes, as I said, it's very complex.
Thank you so much, sir. Students are expressing their gratitude. They are so thankful that you answered the question. This is the last question. With your permission, I would like to take other questions. I think you have already given the answers and explaining the answers of the asked questions. So, with your kind consent, last question, sir. Yes, sir.
Yeah, go ahead. Go ahead.
Just says that how the growth in the domain of IPR is encouraging biopiracy in the international arena.
See, my point is, you say biopiracy, as I said, that it's a package deal. Whenever certain laws, what you put it, everybody, many of you may not know, the original biopiracy issue started with the patenting of haldi and then neem in the early 90s, late 80s. Many of you may not know, haldi and neem all were filed by people of Indian origin, right? Because though they did not even know about homegrown medicine, we knew about it when we went to America. So what I am trying to tell, as long as anything which you try legally, as long as you produce a software, there'll be a hacker. Always. So the point, what I'm trying to tell, it has been checkmated thanks to traditional knowledge digital library which India made, TKDL. Earlier, even the patent offices around the world did not even know that biopiracy is happening, because when they asked you, Aldi, how did you? No, we used it. Every grandmother in this country knows. But the point, grandmother's oral, evidence is not taken in American patent office. Because we and I know grandmothers very creatively can lie also, right? Grandmothers are creative either way. So the point, what I'm trying to tell, then finally, Nizam Museum in Hyderabad produced a document about haldi in post-surgical use. That was the claim. Not just haldi, dermal. How post-surgical. Then they had a Nizam Museum in Hyderabad, had a old document, somebody praising the Nawab at the time, telling home delivery used to happen and skillful midwives used to, deliver, and after cutting umbilical cord, they used to smear the paste of haldi there. Then we interpreted cutting umbilical cord is surgery, putting haldi there is post-surgical, so this claim is invalid. Then that has been chased Urdu. Then the American patent office, is it the correct translation you are giving? Authenticated. Then that was one of the starting point. We started TKDL. And there's a big debate. Don't put TKDL digitally. Everything will be taken by the foreigners. And let it be oral tradition. If you have oral tradition, you have a problem in some jurisdiction. If you put it in writing, you think everybody will be taken away. So this will be a problem which will continue. India at least has stopped. In Indian patent law, we have that you have to go to the local biodiversity board if any genetic material is used. That is a thing. In worldwide, America, Japan did not accept it. They thought it's bureaucratic and red tape and things like that. They said India tried in TRIPS to bring some clauses in the TRIPS level, but India could not succeed because they had a different view. But as I said, the biopiracy part, thanks to internet, thanks to very alert communities today, everything is being analyzed. I would not say it will not happen. It will continue. But it is not the way what it happened earlier. Today, dissemination is faster. Many people are challenging and doing many things. So, that the word biopiracy was more prevalent in our narrative and discourse in the 90s. It is not that much now, in a way. That is the whole thing.
Thank you so much, sir. You rightly said that our tradition, I mean Indian tradition, in which Shruti Smriti was only there, documentation was not there. That has affected many of the things in getting it patented under IPR. But now, as you said, that the situation which was there in 90s is improving and is different than what it was, and let us hope that it would be more vigilant in future. What it was now, it is better than what it was. In future it would be better than what it is. uh, with that hope, we are so thankful to you for your lecture, and I invite Dr. Vidisha for offering official vote of thanks on behalf of GLS Law College to the esteemed guest, Dr. Vivekanandan sir. Over
Thank
to
you.
Vidhi ma'am.
Am I audible, Parman?
Yeah.
Yes.
Okay. Very good morning to Vivekanand sir, Mayuri ma'am, who is always there with us. With her blessing, we have started this webinar. And all of you, first of all, I would like to wish the happy World IP Day, because I believe that each and every individual on this earth has some unique creativity and some skills. Sir, on behalf of GLS Law College, I profoundly like to thank you for sparing your valuable time and enlightening all the students and all those who are listening, the advocates, the professionals, academicians. Uh, Sir, you have started with all the different aspects, starting from the COVID, how IPR and this pandemic, the softwares and the vaccine, how it has been correlated. So, sir, thank you very much for enlightening everyone. Sir very rightly said that IPR is something which is between comfort zone and fundamental needs. So, sir, I truly believe in it. Sir, thank you for dealing with all the aspects relating to the subject from pre-TRIPS era to post-TRIPS era. GLS Law College is always going to be privileged for a virtual inauguration by Sir you. Even if, sir, it was a virtual inauguration, but this will be a very important and always going to be a very thoughtful, sir. Thank you so much. Thank you so much for giving all the guidance and tips for the clinic. Sir, I have noted all of the tips that you have given, all the guidance that you have put up. So we will work according to it. Thank you very much, sir. Special thanks to Mayuri ma'am because of her vision and always helping us to think broad. Because of her, we are doing all these webinars in such situations. Because of her, GLS is what it is today in the 6th year. Thank you so much, ma'am, and all the GLS Law College family members, all the students, all the participants attending the webinar, and the very special thanks to Payal ma'am for making all the webinars on the e-platform of GLS Law College so successful and smooth. Thank you very much, sir. Thank you. Sir, one more thing I want to add here. Yeah, we are ending this with a very nice word which you have tell that we should not focus on IP litigation but on the IP managers. So it is very important that students should understand on all these things. So thank you very much, sir.
Thank you. Thank you. I'll take leave.
Okay, sir. Once again, thank you so much. Thank you, Vidhi ma'am. It was a great day, sir, with you. And we are looking
Thank you so
forward for
much.
having more sessions with you in future as well. Once
Thank
again,
you. Thank you. I wish a speedy recovery to your director. Right.
yes,
Thank you.
yes, thank you.